Good morning, students. How are you? I hope you are quite well at home and today you are well prepared. You are well prepared for today's test. Rather, it will be your trial. Previously, we were conducting trial by judicial magistrate. Now it will be your trial. Let us see. Yes, students, today I am going to discuss one of the most important aspect or concept of criminal law. Since we have already discussed trial before a court of session, trial of warrant cases by judicial magistrate, trial of summon cases by judicial magistrate. Now I am going to link this trial with a very important concept, that is confession. Confession word is well familiar with criminal law and very important word in criminal law. And today I will throw light on this confession, that what is in fact confession. First of all, you may not write anything. I will dictate each and everything. I will dictate each and everything. Now, confession means the statement given by an accused whereby he admits that he has committed the offense. Now, this is known as confessional statement. I will give an example so that you may not miss here. In the start, first of all, have a grip that what is in fact confession. Now, I will give an example here. A has killed B with the revolver. And he made the statement that he has killed B with his own revolver. Now, this statement is known to be the confession because this person has himself admitted that he has done this thing. He has committed this offense. When some statement indicates that somebody has himself has admitted his guilt, we will say this is confession, confessional statement. Now the question is whether this confessional statement is to be read against that accused by the courts or not. That is the important point. Whether the confession made by someone, some accused, is to be relied upon, is to be believed by the court, whether it is credible, whether we can give punishment to that person on the basis of his confession. Now I think you have understood what is confession. And let me link it with constitution. Now this constitution provides in Article 20 clause 3 that it is providing doctrine of self-incrimination. Now it lays down, this article lays down that no person accused of any offense shall be compelled to be a witness against himself. Now, this constitutional provision puts a bar that nobody should be compelled to state something against him. Now, this confessional statement is against him. But students, our law, our criminal law, which has been framed by Parliament, they have laid down the circumstances in which such a statement can be read, can be relied upon, can be believed by the court. Now, if this statement, if a confessional statement is made to the police, suppose here he has gone to the police station and he has asked them that register an FIR against him because he has committed murder with his own revolver. Now, this will be the confession to the police. We will say that he has made a confessional statement to the police. Now, this confessional statement, they may register an FIR. Absolutely, there is no bar. But we cannot rely upon this statement because confession is made to the police. Whenever confession is made to the police, the court will not believe that confession. Now, it may be SHO, it may be investigating officer, it may be SP, it may be police commissioner. The accused may make the statement before the DGP, who is the head of the police department. Even then we will say that this confession is made to the police. Therefore, it is not admissible. When I say it is not admissible, it means it is not believable. The court will not believe it. Court will not rely upon that statement made to the police. Now, this section 25 of Indian Evidence Act, section 25 of Indian Evidence Act makes it very clear that confession made to the police officer is not to be proved in the court. It means the court will not rely upon that. I must say here that why this provision has been made. Students, you are well familiar with the deeds of the police department, that how they are torturing the person, how they are getting the confession from the accused by hook or by crook. Now, that is why on the basis of our experience of our Indian police, that is why this has been laid down. Secondly, if A has been arrested in this case, and after arrest, he has written in his own handwriting on a white paper that he has committed murder of B with his revolver, and he has written with his own handwriting, and he has put his signatures also on that. Yes, students, this statement will also not be reliable, will not be relied by the police. It will not be believed by the court because it has been given when A was in police custody. Keep in mind that if confession is made to the police officer, maybe when he is not in custody, or if the statement is made to the police when an accused is in custody. Now, both the statements are not believable, and the court will not believe that. Court will not rely upon that. Now the question arises, which confession is reliable? Now here I will disclose to you that confession may be judicial confession or extrajudicial confession. Let me make it clear. What is judicial confession? Judicial confession is when the accused is brought before the court of a judicial magistrate and he get his statement recorded in which he has confessed the offense having been committed by him. Now here we will say that this is a judicial confession duly recorded under section 164 of CRPC because this is legally recorded. Then extrajudicial confession. Extrajudicial confession is when it is made to anybody other than the police. Police we have already discussed that if statement made to the police, it is not admissible. Now let me state that what is extrajudicial confession. Now you have to understand this concept very minutely. Each and every word is important because here you are appearing for PCA judicial, for HCS, for judicial examinations. Therefore, High Court may ask you about this question, what is extrajudicial confession? Let me state that. Now, A, after committing the murder of B, has come to his father, that B, who is real brother of A, has been killed by A with his own revolver. Now this is also confession. We can say confessional statement made to father of A. Now this, if father comes to the court or comes to the police station to register an FIR against his own son, now his statement, father's statement will be admissible, although it is containing confession made by the accused. Now, here we will say that father is narrating extrajudicial confession made by A. Now, this is extrajudicial confession. Now, extrajudicial confession. Now, in this case, you will agree that father's statement will be highly believable because the father is giving statement against his son. He cannot give a false statement. Moreover, his other younger son has been killed. Therefore, his statement is highly believable. Now, this statement will be believed by the court because father is not a police. He has heard, this matter was conveyed by A to father. Therefore, father has narrated his father's statement before the court. Whenever the case will come to the court, father will come to the court and he will give his statement on oath that his son has disclosed to him on so and so date that he has committed this murder. Now his statement will be valid one. Now you must know that which confession is valid and which confession is not valid. Now in this case, father's statement will be believed and it can be used by the court for corroborating, for supporting the other evidence, Therefore, keep this thing in mind that extrajudicial confession is that statement which made to anybody other than the police. Now let us see further. A confessional statement made to the police, sometimes this question may be there, that whether in any circumstance a confession made to the police is admissible. Now there is section 27 of Indian Evidence Act, which lays down that if confession is made to the police, some part of the confession is admissible, is believable, will be used by the court also. Now, I will say that what that part is. Suppose in this case, A has been arrested and A made the statement that he has killed B with his revolver and he has hidden the revolver in some corner of the house underneath the soil. After digging the earth. Now this here, he has made the confession to the police that he has murdered and he has hidden that revolver. Now in this case, what will be the procedure? Now this A will be taken by the police to that place. Police will ask A that you take the police party to that place where he has hidden. Now he will lead the police party to go there. And he will, the police party, after digging the earth, will take that revolver. Now here, something is recovered on the basis of confession. Now this confessional statement will be relied upon to some extent. What is the extent? Now we will accept the statement to the extent that A has hidden this revolver. Simply this thing. We will accept the statement that A has hidden the revolver. Still, the court will not believe his other part where he has stated that he has killed B with this revolver. Now please make it sure that this confessional statement made to the police is admissible only to some extent. Then which is the extent? Only that part of the confessional statement on the basis of which they have discovered something which was hidden by the accused who is giving statement. I think all of you have understood this, that which part of the confession. Now let us see how the confession is recorded by that judicial magistrate under section 164. Now this confessional statement is highly believable because it has been recorded by the judicial magistrate. You have to understand that what is the stage, how, which are the circumstances in which he is making the statement, and in which the judicial magistrate is recording that. Now, for example, in this case, FIR has been registered and A has been arrested. Now, when A was arrested, he confessed before the police that he has committed murder with his own revolver. Now, we have discussed this statement is not admissible, but the police will take this accused to the judicial magistrate with an application that the accused wants to make confession, and the court of a judicial magistrate. Now here also he may or may not have jurisdiction over the case. Under 164 he may or may not have the jurisdiction, but if the accused wants to record confession, he will initiate the proceeding. Now here it is very important to listen to this his initiation, that how will he will initiate. Now he will ask the accused whether he really wants to make the statement. If the accused says yes, he wants to make the statement, then the judicial magistrate will further alert him that, look here, gentleman, if you make the statement, it may be read against you. And on the basis of this, you can be convicted and you can be given punishment. Therefore, you are at liberty to withdraw. You may not record the statement. Here, there is no pressure of the police. If you say that you don't want to record the confession statement, the matter will be over. I will not record the statement. Suppose during this process, accused made up his mind that really the magistrate is alerting him on this aspect, and he withdraws and he says that he do not want to give confession statement. Now here, very important thing. Now if the police says that he has here retracted, he has refused, he has here not made the confessional statement as per his earlier promise, therefore he should be sent to police custody for 2 or 3 days, because they want to interrogate him. Now students, you are well aware that what kind of treatment the police will give to that person who has refused to give statement. Earlier, he has made the statement. On the basis of his statement, the police has brought him before the judicial magistrate, and now they are asking for remand. And you are well aware that to what extent they will torture him in the police station. Now, therefore, there is a mandatory condition that if accused refuses to record his confessional statement before the judicial magistrate, then the judicial magistrate will not send him to the police station, will not grant police remand. Now, in this case, what he will do? He will send A to jail. He will send A, it will be judicial custody. A will be sent to jail and he will be kept in jail. Now, suppose after alerting him, after giving warning to the accused by the judicial magistrate, still the accused says, "Sir, I want to confess because it is having great burden upon my head. I want to get rid of that burden. I want to confess my offense, whatever the punishment may be. I am ready to bear that punishment." Now, if this is so, only then the judicial magistrate will record the statement. Now, here also the question will arise that which is the stage when the judicial magistrate can record the statement under section 164 of CRPC. Now, this statement of confession of accused can be recorded during investigation. Please keep in mind, it is during investigation or before the commencement of trial or inquiry. In other words, since I have disclosed to you people all the stages of trial, then you will easily now know that this is the stage. It means before presenting police report, this statement can be recorded under section 164. Or if the accused has been sent to jail, for example, A has been sent to jail, when he says that he doesn't want to make the statement. But after 1 month, he has expressed his desire again before the magistrate. Sir, now I have made up my mind to make the confessional statement and I'm ready. You please record the confession. On the other hand, police has not yet concluded the investigation and has not yet produced the police report before the court. Now this is still stays because it is still before the commencement of inquiry or trial, because the inquiry is to be conducted only on the receipt of the police report. Therefore, till the police report is presented, the accused may come to the court and his statement will be recorded. Now suppose the judicial magistrate has started recording the statement, and even in between, when the judicial magistrate has not concluded, the accused may withdraw. He may say that he does not want to make confessional statement. Why this is so? Because we are to keep in mind Article 20, this clause 3 also, doctrine of self-incrimination, that his confession must be voluntarily. His confession should not be under some compelling circumstances. That is why now here he has come to the court voluntarily and he is recording his state voluntarily. Now after concluding the statement, the judicial magistrate, he will get his signatures and he will put his signatures also. And at the foot of the statement recorded by the judicial magistrate, the judicial magistrate will record that he has already warned this accused and he has already disclosed to this court, this accused, that he is not bound to make the statement. And I have also disclosed that if he makes the statement confessing the offense, it may be read against him and he may be given punishment. And after alerting him, now the judicial magistrate is writing his footnote. He will write that I am convinced that this statement is voluntarily. It has been given by the accused voluntarily. And he will write there that he has written the statement and it is containing full disclosure without any addition and deletion. And he will also put signatures under that note. Now this statement is a valid statement made under section 164. Now the question arises, when this statement is recorded, at which stage it can be used? Now in this case, when he has made the statement, the judicial magistrate cannot convict the accused on the basis of that statement. Or even session judge cannot convict the accused on the basis of that statement unless the police report comes. Because the police is still conducting investigation. Police will take the copy of that confessional statement and then it will conclude the investigation and present the police challan. And after presenting the police challan, the judicial magistrate will commit the case to the court of session. Then it is the court of session. I have already discussed what the court of session will do. It will also not convict the accused immediately on the basis of his confession? Absolutely no. It has to adopt the procedure we have discussed from section 225 to section 237, where this court of session is conducting trial. And it is the stage when the charges are framed under section 228. Now there also he will be again asked whether he pleads guilty or not. Although accused has given confessional statement, but still there he can say, I do not plead guilty. There is no bar on him. And if he say, I do not plead guilty, the court of session, it will conduct the trial. And in trial, it will see that what value this confessional statement before the police is carrying. Because that is very important. At every stage we have discussed that if he has pleaded guilty, the court may or may not convict him. The discretion has been given. Why this is so? Because sometimes it may be that on the basis of evidence, the accused may be acquitted. Now I will tell you one very interesting story here of our own High Court. Then you will know that why this discretion has been given to the courts, that they must first of all satisfy themselves. Now there was a murder case. Many accused were arrested for killing, let us see, for killing X. 7 persons were arrested and 7 persons were tried and they were given life imprisonment. And they were inside jail continuously for 1 year. And they have simultaneously filed appeal, which was pending before our own Honorable High Court. Now, Honorable High Court there, the public prosecutor, the Advocate General on behalf of the state, they have stressed upon that all these persons, they have committed murder and they must be given rather death penalty, because life imprisonment has been given by the court of session. Now the public prosecutor is making the request for death penalty. On the other hand, the advocate of accused, he is making the prayer, look here sir, my accused, they are innocent, they have not committed any murder. At that juncture, students, very interesting thing appears. Now X, who was murdered, now he appeared before the High Court. He says that, sir, I have never been murdered. Now you can now well imagine that what is the situation, that X who was murdered, he has appeared. Everybody say whether it is X is a ghost or he is a real person. Now in this case, our High Court was also surprised to see that what happened. Judicial magistrate has granted the police remand. Session judge has conducted the trial. He has taken 1 or 2 years. And after trial, session judge has given the punishment. Oh, what is this? How this happened? The next disclosed that he has been confined by the police continuously. And now he has made arrangement to run away from that place. He is directly coming here to the court because he was having apprehension that he may not be killed thereafter. Now you can well imagine that to what extent the police is torturing the accused and how they are compelling them to confess. Now in this case, accused who have undergone the imprisonment without any fault on their part, and they remained inside jail. Now in this case, High Court took a very serious note of this. And High Court has asked the government that you pay rupees 25 lakh to each accused who remained inside jail who has undergone such an agony, and they completed 1 year. And the government was compelled to pay rupees 25 lakh to each of the accused. And thereafter, High Court did not remain silent. High Court has passed an order that all police officers who conducted the investigation, they should be arrested, who were involved in that. And those persons of the villagers who have identified the dead body of X, they should also be arrested. And now this case is relating to Moga district, and the case is still going on against many police officers, that what they have done in this case for implicating these many persons. Yes, students. Now, I had come to this example for making you people understand that why the judicial magistrate or session court has given that discretion, that even if the accused has confessed that he has committed the murder, they should not believe blindly. They should conduct the inquiry and trial, because the murdered person may be alive, very much alive. Therefore, this is the discretion. Why? This is the reason why discretion has been given to the court of session or to the court of judicial magistrate, that don't believe this confession blindly. Now, sometime confession, it was confession statement made by the judicial magistrate. Now, sometime what may happen? Now, I will give one example, then I will make you people understand that also. There were 7 persons who have committed dacoity in the bank, and they have looted 20 lakh rupees. And they have left no clue except camera, because camera has catched some scene when they entered, but their faces were properly, they were wearing mask, because masks were there on the mouth, they cannot be recognized. And the police was confused that what is to be done. They have arrested these persons on the ground, on the apprehension that they are the persons who might have committed that. Now, out of these persons, this X, X, he has asked the police that he wants to make confession. And he was brought to the judicial magistrate, and he has made the confession that he, along with 6 other persons who were arrested, committed this dacoity and looted 20 lakh rupees from the bank. And he disclosed that this amount is lying in the houses of 2 persons, 2 accused. And firstly, the police, on the basis of this statement, recovered that amount. But still, the evidence is not sufficient to convict all these accused. And they brought this X before the court, and he has confessed that he has, along with 6 persons, has committed this dacoity. Now, this X has narrated each and everything. But thereafter, he was sent to jail, and an application was also moved by the police that when investigation was going on, X expressed his desire to become a prover. A prover or accomplice. Now these are the new words I will have to disclose to what was a prover. Now in this case, evidence is not sufficient to convict the accused. Therefore, the case of the police will fail, and all of the accused will be acquitted. Now, in such a situation, one of the accused who wants to make confession, he may be made a prover. A prover is that accused who has been made a witness, government witness. In Hindi, Punjabi, we call sarkari gawah. Sarkari gawah. The court can tender pardon. Court can make X to be sarkari gawah. We will say that X has been made a prover. And he is also called accomplice. Accomplice is that person who has participated in committing some offense along with other persons. Now here, X has committed this dacoity while participating with other accused. Therefore, he is accomplice. Now, if the court is competent, the court is competent to make a person, to Chief Judicial Magistrate is competent to make a person to be the approver, to be sarkari gawah, and in that case, X will be known as a government witness. He will not be now known as accused, but he will be kept inside jail because it is a case of dacoity, and the trial will be started, and he will appear as a witness. Now he will not be in the name of the accused, because when the police will present the challan, police will show him to be a witness, and they will show the list of accused, which will be containing only 6 persons. Now this is a contract between the court and this accused. That accused will narrate each and everything which he has narrated in the confessional statement before the trial court when he will appear to give evidence there. Now, in this case, a contract has been made, and in that writing, the X will be acquitted ultimately. If the X has given the same statement, confessional statement, in trial when evidence was being recorded, let me remind you, which will be the stage? Now we will say it will be the stage when evidence is recorded by the court of session if session judge is trying under section 231. Because 231, that is the stage to record his statement on oath. Now please keep in mind that this statement recorded by X will be on oath, but earlier statement which he has made to the judicial magistrate, that was a confessional statement and confessional statement cannot be given on oath. Rather, in confessional statement, the judicial magistrate is alerting the accused that you are not bound to make the statement. You can withdraw. You can at any time say that you don't want to make the statement. That is why we don't record confessional statement on oath, because here rather some warning is given. Some warning is given to X that he may withdraw. Now, X will be known as approver. X will also be known as accomplice. Question is that X was friend of 6 accused earlier. Now he is making some statement only for the purpose of that he may be absolved of his criminal liability. Now, therefore, he may be telling a lie. The question is whether his statement is really believable or not, because earlier he has committed the offense with other persons. Now he, for the sake of being acquitted, that he will be acquitted, he is making the statement. Now, Section 114 of Indian Evidence Act, illustration B, makes it very clear that such a person like X is unworthy of credit. He is not believable. But his statement can only be believed if some other material is corroborating this statement. Because this statement can be taken into consideration if it is supporting other evidence. Independently, we suppose there is not other evidence, we cannot convict these accused on the basis of only his statement. Now, in this case, this X will also be cross-examined by these accused, by the advocate of these accused, because now he is the witness, he is not accused. Therefore, he can also be here cross-examined. Now, Section 133 of Indian Evidence Act. Now, both sections are of Indian Evidence Act. Section 133 of Indian Evidence Act says that it is not illegal to convict the other accused on the basis of evidence of accomplice. Now, contradictory situation is there. But Honorable Supreme Court in various authorities have held that the statement of accomplice should be believed only if other evidence is also supporting that statement. Other evidence is also corroborating that statement. Corroborating means supporting that. Supporting that statement, only then his statement should be believed, otherwise not believed. Now, since we are discussing this confession, now let me say that if confession made by co-accused, whether that confession is having any value or not. Let me here give one example. Now, there were 3 accused, X, Y, Z. And they together committed theft in a house, and they are being tried. Now, this X, he has made the confession. He has made the confession that He has committed the offense along with Y and Z. All the three persons they have planned earlier, and thereafter they have gone there. They have taken some items from that house, and they have committed theft like this. But he does not want to become a prover. Now, in this case, what will happen? X can be convicted because discretion is with the judge. He may be convicted for having committed this. And his statement alone will not be sufficient to convict Y and Z. Please keep in mind, this is confession made by co-accused. We call it co-accused. Now, section 30 of Indian Evidence Act says that X may be convicted on the basis of his statement, but that statement alone will not be sufficient for convicting other accused Y and Z. Now, please keep all these things in mind while discussing this confession. Now, confession may be a very, very important thing. Yes, confession may be exculpatory. Please keep in mind this exculpatory. It may be inculpatory. Now, two types of confession may be there. Exculpatory or inculpatory. Exculpatory confession is that confession which is free from any blame, which is not accusing any person. And inculpatory mean it is a blameworthy. I will give you one example. Only then you will understand that what is exculpatory, what is inculpatory. Now, this A, he has caused one head injury on the person of X with a sword, and X has killed. He has been killed like this. And here, A has made the statement. Let me here write that. Then what? No. You are not to write. You are not to write. You are not to write anything, because I have already disclosed to you that nothing should be written by you. I will dictate each and everything. But here you have to understand. You have to understand. I will write on the board to make you people. Now here A says, I have killed X with sword as he entered into his house with a revolver in his hand. Now this is the statement. I think all of it is visible to all of you. What he says? He says, I have killed X with sword as he entered into his house with the revolver in his hand. One thing more I have missed here. At 11:30 p.m. 11:30 p.m. Now, in this case, this statement, I have killed X with sword, it is inculpatory. It is inculpatory because it is a blameworthy. It is a inculpatory statement. Now, this statement, as he entered into house with the revolver in his hand. Now, this is exculpatory. This is exculpatory. Now, the question arises whether we can say, whether we can ignore this portion, later portion, or not. Now, Honorable Supreme Court, in a full bench, in Palvinder Kaur versus State of Punjab, AIR 1952, Supreme Court 354, 3 judges were there. Now, they have held that we are to admit the entire statement. We are to admit the entire statement, and statement must be admitted as a whole. We cannot see only I have killed X with sword. We are to see other portion also. Now, we cannot ignore this. This has to be right. Now, I will here say you, suppose in this case, this X was killed on the road outside the house, and A is saying this thing. It means he is confessing that he has killed with sword, but he is adding something from him. Now the question is whether now we can accept, but at that stage, Honorable Supreme Court has held, no. We cannot accept his only inculpatory statement. We have to tag exculpatory statement also. It means we have to read as a whole. Now, even if next, suppose there was a camera has catched the situation while this A was causing injury on the head of this X outside the house. Now, here also, Honorable Supreme Court has said that we cannot accept his confession. Only this inculpatory statement, because exculpatory statement must also be attached. Now, in other case also, Hanuman Govind versus State of MP, Madhya Pradesh, AIR 1952, Supreme Court 343 page. In the same also, it was held. The same thing was held, that as a whole we are to consider his confessional statement. We cannot believe in part. But this matter again came before Honorable Supreme Court in a constitutional bench. Yes, students, you must know what is a constitutional bench. Constitutional bench is that bench where 5 judges are sitting together to discuss some point, some legal point. Now here, It is Nishikant versus State of Bihar, AIR 1969, Supreme Court. Or here 5 judges were there. Now, in this case, 5 judges have discussed these authorities, and they have held that no doubt we are to accept the statement as a whole. But if some evidence is proving that his exculpatory statement is false, then we must ignore his exculpatory statement. And we must ignore this portion as he entered into his house with the revolver. We must ignore. Now here, the video clip is very clear. It is showing that he was murdered outside. Therefore, as per this authority, we can ignore. We can ignore this. We can ignore this. Now, another very important thing. Now, whether confession made by the accused at the time of this narco test, polygraph test. Now, it is there was one case in which the Honorable Supreme Court has held that lie detector test can also be conducted, because that is a latest technique. First of all, let me tell you what is a narco test. What is a lie detector test? Now, there is one apparatus which is put on the body of the person, and it is being controlled by doctors. And a situation comes when the person he states each and every truth. He speaks truth about any offense, whatever. Now, he may say there that I have gone to that house of the that person and I killed there. I was having revolver, I was having knife, whatever may be. He will speak truth. That is why we say lie detector test. He will not tell a lie there. But it will be conducted by the doctors in the presence of the advocate of the accused. And it cannot be conducted unless accused himself gives consent that he is ready, because he is innocent. He has done nothing. He has been falsely implicated. You conduct this lie detector test also. He is ready to conduct this narco test. Now, Honorable Supreme Court in a case, now please, you must keep in mind that Shrimati Selvi versus State of Karnataka, there, this case is very important. In this case, Honorable Supreme Court has held that if in this statement the accused makes confessional statement, it is not admissible, because that statement will be to the police. Section 25, 26 of Indian Evidence Act will again be applicable. But on the basis of that statement, Section 27 of Indian Evidence Act will be applicable, and the police can record his statement. And if something is hidden somewhere, it can be discovered. Now, thus, this test is certified by the doctors that while the accused was speaking, they were there, they were hearing, and their apparatus was going on. It was in right action. There was no fault in that machinery. And therefore, the consent of accused must be there. Yes, students, this was about confession at various stages. Now, let me come to our today's process, because you are now to appear in a test. You are going to receive the test in a very short period. But please keep in mind that don't take the help of any book. Don't take the help of any copy. Don't take the help of any person who is sitting around you. Don't seek any answer on phone from anybody. Because here, I cannot supervise you people. Because when you were sitting in the class, I was having full control. I can see whether a student is copying or not. Therefore, because if you will do that, you will really cheat yourself. You will really bluff yourself, because nobody will be cheated by that. Why I am saying this thing? Because I will be able to assess your performance, and I will talk to each one of you on phone that you should improve in this way. You should do in this way. But if you start copying, if you start cheating, then you will be at loss, nobody else. Now here, I will ask you please that first of all take oath. Wherever you are sitting, rise, stand there, and we will take together oath. Don't bother that your parents are sitting, your near and dear are sitting. Because when you are to function as a judge, you are to function as a judge. You are to control the entire gathering, maybe 10 advocates, maybe 20 accused, maybe 50 persons. Therefore, concentrate over that oath. Now I will say, and you will say here, you will follow me word by word. We are going to take oath. Now, first of all, take this situation that I take oath that I will not take help of my copy or any book, or I will not ask answer from any person. Thank you. Now you will receive that paper. Keep in mind that you are given only 25 minutes. 25 minutes. 25 minutes. You will be given 25 minutes from the receipt of this. If your answer sheet is received late, 10 marks will be deducted. And I will presume that you are trying to consult some book, but since you have taken oath, be sincere to yourself, because you are to be sincere. Here that formula is to be adopted. Be sincere to yourself. Then you will see within a very short period, you will start getting 100 out of 100 marks. Therefore, solve it within 25 minutes. We have given 25 minutes only for this week, but from next it will be 20 minutes. Therefore, make your speed like this. Therefore, don't create such a situation where 10 marks may be deducted. All the best, students. Thank you.